What you're about to experience is one man's quest to see beyond the tumultuous period we're in and to envision what lies just beyond our grasp, yet well within our reach. Welcome to Larry Rifkin's America Trends, where the future has arrived, and it's just in time.
Welcome back to America Trends. I'm Larry Rifkin along with John Krofsik. And John, you know, when the framers designed the Constitution, well, imagine with me, which branch did they look at as being the most powerful branch?
Well, I think the design was not to have one powerful branch, but to spread it out so that nobody had the power.
However, if you look at, Article 1, it really was about the Congress and Congress's
right, they're
powers.
the lawmakers, yes.
Well, because, we elect them every 2 years. We elect them closest to home. So there is something about Congress that is meant to be just a little bit special.
Right.
For example, they can override the president. So if he vetoes something, they can override his veto.
When was the last time that happened, by the way?
Well, that hasn't happened in a while. We're not talking about the dysfunctional Congress that we have today.
Right.
But most observers of government would agree that Congress today is among the weakest branches of government. In fact, many people feel that when the Republicans were in total control of the Congress, they were a subsidiary of the executive branch.
Well, I think that's true. They've given away their power. They want him to fail on his own with executive orders. This way, they don't have to do anything, get reelected, and look fine.
Well, executive orders is one thing, and you're right. And then there were those signing statements that I remember. I don't know how many Donald Trump has done, but I know that Barack Obama and George W. Bush had a lot of signing statements where they said, I will make certain that we carry out these laws and this portion of these laws, but not necessarily other portions of these laws. So they try to get around Congress in many ways. But there's another insipid movement that is afoot, according to Peter Wallison from the American Enterprise Institute. And he's also the author, John, of the book Judicial Fortitude. And he's saying that unelected administrative agencies of the executive branch, again, all related to the very powerful presidency that seems to have emerged and superseded the Congress, that these administrative agencies are taking over many of the responsibilities of Congress.
Wow. It's pretty scary what's going on. And you'd think that Congress would want to take their power back but I guess then again, with that much power, if they took it back, they would actually have to do stuff. So
that's the other point.
Sword.
That Congress, their major responsibility in their minds is to get reelected. Right. Therefore, how vague can we make laws so that no one can pin the tail on this donkey? And I'm not talking about the donkeys of the parties. I'm saying how much can we get away with saying we did something, but not really being very express in what it is that we intended. Leave that to the administrative agencies or leave that to the courts and let them figure out whether we've exceeded our powers or whether we've actually made a law that has any teeth to it.
Yeah, it's really, I don't know how we're going to get this country back out of the hands of big dollars and a Congress that's useless.
Yeah, I know. We are there right now. And that's why I think this book is really interesting. Again, it's called Judicial Fortitude. And it's the last chance, according to Peter Wallison, John, to rein in the administrative state. So let's find out what we're talking about here. How many agencies, which are the powerful ones, and how much authority does Congress really cede to these agencies?
Well, let's get him on and talk about that because I want to know.
All right. That's all today on America Trends. Thanks for being here. The book is called Judicial Fortitude, The Last Chance to Rein in the Administrative State. Peter Wallison is with us, as he has been in the past. Peter, what is the administrative state?
The administrative state consists of all of the agencies of the federal government, starting with the big agencies like the Treasury Department or HHS, all the way down through hundreds of others to, say, the SEC or the FCC. So all of them, and they're probably several hundred.
And this administrative state that you talk about that you think we really need to be wary of, I mean, when did it begin to build? You do talk about the progressive era, but give us some history.
Yeah, well, back in the progressive era, I think it is a little important for your listeners to understand this. Back in the progressive era, which was between 1880 and about 1920, the idea developed that it was necessary to modify the Constitution in some way so that more of the decisions for society could be made by credentialed, intelligent, disinterested people who would regulate the economy. And that idea was very popular during this period. It faded a little bit in the 1920s, but then when the New Deal occurred during the time of the Treasury, during the time of the Depression, it came back. And under FDR and the New Dealers at that time, many, many new organizations were set up in the federal government to regulate or otherwise administer various areas of the American economy and the American system. So that's the history of these agencies. And once they became common and were engaged in their activities under laws that were passed by Congress, then they began to expand. And that's where things became quite troubling, because in 1984, the Supreme Court adopted a decision called Chevron versus Natural Resources Defense Council. And in that decision, the court decided that courts, all the lower courts, should defer to the interpretations of the agencies of what their statutory powers were. So this obviously gave them a tremendous amount of opportunity to expand their activities. Not only could they interpret new statutes, but they had a whole lot of old statutes that they'd been administering for years, and these they could reinterpret to give them much more authority.
Who have they taken the power from? Is it the legislative branch?
Well, they were given this power by Congress. No agency of the government, including the president, really can do anything without the authority of a congressional statute of some kind. And unfortunately, once the statute is passed, then these agencies are able to take advantage of that by expanding their power tremendously. So, for example, since 1993, when people started to count, in every year since 1993, we've had more than 3,000 rules and regulations issued by the agencies of the administrative state, of the federal government. That's a total up through the end of 2017 of 101,000 rules and regulations. So you can get an idea of how pervasive this is.
Well, why is it that the legislation goes over to administrative agencies with so little definition? Why is it written so broadly? Somebody listening to this might ask.
Yes, and that's a very legitimate question. And the problem is that Congress has found it very easy, very convenient for them to transfer to the agencies a lot of the decisions that in a democracy Congress ought to make by itself. So, for example, two of the classic examples are the Clean Air Act and the Clean Water Act. And in those cases, there are lots of decisions made about who should bear the cost and whose property would be burdened by the regulations, but those decisions were never made by Congress. They were passed to the Environmental Protection Agency, which makes those very difficult decisions because, in part, the members of Congress don't want to make those decisions. Those cost them support among their constituents. And so it's much easier for them simply to adopt legislation that says you, agency, clean up the air, clean up the water, and then they go to their constituents and they say, see, I've solved the problem. I've passed the Clean Air Act and the Clean Water Act. But in fact, they didn't solve the problem. They gave the power to an administrative agency to solve the problem. And those agencies, which exist right around Washington, D.C., and are made up of unelected people, are making the decisions that Congress really ought to make. So that's what the danger is here.
Now, what about the oversight?
Danger to our democracy.
Yeah, what about the oversight from Congress? In other words, isn't there a regulatory review process? And they look at it and say, yes, that was the intent of the law, and you have carried it forward appropriately, or you've overreached.
I'm afraid that doesn't happen. First of all, as I suggested, there are 3,000 regulations and rules in every year, and Congress would be complete. And first of all, not only are there 3,000 of them, but they're hundreds of pages long. And so for Congress to review these things is not possible with all of the other responsibilities that Congress has. It's also not possible for the president to review these regulations. The president does review some, or at least his staff reviews some of the most important regulations, but that would be maybe 5 or 6 in any year out of the 3,000. So no one is really controlling what these agencies are doing. And the only way it seems to me, for that to be done is to have the courts step in and modify the Chevron decision that I talked about before, so that instead of deferring to the agencies about when they decide what powers they have, the courts would decide, looking at the statute, whether the agencies actually have the power to do what they say they have the power to do.
I think people would be shocked, though, to believe that somebody who is really aggrieved by virtue of what the administrative state has done on one issue or another hasn't gone before the courts, because the courts themselves won't take it up unless somebody brings it to them, correct?
That's right. And what has happened, of course, is that with this Chevron decision, which meant that the courts had to defer to the agency's interpretations, many businesses and others who were aggrieved went to their lawyers and said, well, wait a minute, where does the agency get the authority to do what it just did? And the lawyer said, look, I'm perfectly happy to bring this case for you, and you can pay me for it, but I have to tell you honestly that it's going to be very hard to win, because the Supreme Court has told the lower courts that we will be looking to that they should defer to the agency's interpretation. So a lot of cases are not brought, and those cases would have the effect of reducing the power of the agency or invalidating regulations that the agency has put out, but people just don't want to spend the money to lose in the courts.
And when we look at this, I know a lot of people talk about the imperial presidency, and the president, of course, oversees the activities of the executive branch. Does this play into even greater power and authority for an executive, or no? Are these little islands unto themselves, even though they're part of the executive branch, they're acting independent of whatever the current administration may be?
Yeah, well, I think you're entirely right. They are islands unto themselves. As I say, maybe 5 or 6 of the major regulations that come out in a year might be reviewed by the president, but all of the other regulations that are coming out were made under statutes that were adopted before this president got into office, and are now just the meat and potatoes of what these agencies do. And they're constantly putting out new regulations and rules, because in this way they can demonstrate their power and they can get more appropriations from Congress and all of those things that are part of being a bureaucrat.
We understand that the judiciary perhaps has given a lot of this authority up and said in the Chevron case that it is the ability of these administrative organizations to kind of call the very specific shots that really determine how legislation is implemented. Do you think that, again, that there's going to be a case that is either before a district court or an appellate court right now or the Supreme Court that might pull back on that at a time when we hear that the Trump administration is trying to scratch out some of these rules and regulations. It would seem like this would be their moment in time, particularly the way the president also is getting a lot of appointments onto these courts.
Yeah, and in fact, the people he is appointing to these courts are people who would look very carefully at this. Now we have, because of the president's two appointments to the Supreme Court, recently confirmed, Brett Kavanaugh, there are now 5 members of the court who have in past cases said that they are concerned about the breadth of the agency's activities and about the Chevron case. So when a case comes before the court, there may well be a decision by the court because of these new appointments in Gorsuch and Kavanaugh. That may be a case where the court will come down 5-4, modifying or eliminating the so-called Chevron deference decision. Unfortunately, there is one case before the court right now. It was argued on October 1, but because of the problems in the Kavanaugh nomination, he was not able to attend. He was not confirmed at that point, and therefore it was argued without him. So it may well be that when this case is finally decided, it will come out 4-4, and we'll have to wait for another case to come before the court where the majority of constitutional people, and that is Kavanaugh, Gorsuch, Roberts, Alito, and
Thomas.
Thomas, that's right. Skipped my mind there for a minute. They will all be there, 5 of them, and they would be likely to make some major changes at that point.
What about the incestuous relationship between these administrative agencies and those whom they do regulate? I mean, there is that other concern that, aside from being independent of perhaps legislative intent and the legislature willing to let them kind of go their own direction, and the judiciary not being asked to get involved and they can't get involved on their own request, then what about this incestuous relationship that takes place between those who are regulated and those who are regulators, and we see a revolving door at times between the agencies and those in the private sector?
That's a great question and a very sophisticated question, and the fact is that it is a problem. The whole idea during the progressive era that we talked about moments ago was that all these people would be disinterested. They'd only be interested in the welfare of the population and of the country. But as it has turned out, they become very friendly with the industries that they regulate. And what happens is many of these rules are sort of negotiated with the industries that are regulated, and they are not effective in doing what Congress actually wanted the agency to do. Even though the agency was given a lot of power, it simply helps some of the industries that it is regulating. And this is very unfortunate because regulation in many ways keeps out competition, because the groups that are already regulated in working with the agency get regulations that make it tougher for new competition to enter the field. Because it's expensive, you have to learn a lot about the new regulations in the field. There are many new regulations that you have to now comply with, and so people are discouraged from coming into the field and competing. So it works both ways. The agencies are making rules that the American people are very unhappy with very often. They don't feel that they've gone through Congress as they should in a democratic country. They haven't been adopted by the people who are supposed to represent the voters. On the other hand, many of the regulations that come out are favorable to the industries that are regulated. So there's really a lot of question whether we need all these regulations. And one of the things that would happen if we were able to get the changes at the Supreme Court level that I've been discussing is that there would be fewer regulations because the Congress, whatever it did, would then find that the courts would be cutting back on what these regulations do because the Congress has not provided the authority for the agency, in many cases, authority for the agency to do what it's trying to do.
I guess I'm still confused as to why, so many parties who are affected by these administrative actions must leave the dialogue with a lot of bitterness. Why there aren't more court cases challenging, many of the rules that have been implemented. I assume there are, but they just either die where, in district court or appellate court or whatever. What's happening there within the judiciary?
Well, they do die in the lower courts, and they die very frequently because of this Chevron case. Chevron is the most cited case of any in the courts.
Really?
And the reason it is the most cited case is that the agencies have been able to use it very successfully to beat back any challenges to their regulatory powers. If we can eliminate the Chevron case, we'd have a completely different system. That would not be the end, I have to say, because there's more to be done. But the first step that the Supreme Court should do is to eliminate or modify Chevron so that it doesn't give the agencies a big leg up in litigating with aggrieved people.
Are there certain agencies of the executive branch of the federal government that have a great zeal about rulemaking, as opposed to others who are much more laid back about it or less determined to utilize what powers they have assumed with a rather allowing Congress and a judiciary that is somewhat hamstrung in providing judicial oversight of much of this?
It's hard to identify any agency in particular. Some of them are worse than others. Some of them put out rules all the time. Others have a whole set of rules already, which they then enforce against the regulated industry. So I can't really name one, but let me give you an example of how an agency uses a rule or a law to enhance its power and its scope. In 1972, Congress adopted a rule, a law under the Education Acts, and the law said basically that you cannot, if you're accepting money from the federal government for education purposes, you cannot deny all of the education benefits that you're providing to women. Women and men have to be treated the same. That seems very reasonable. However, it referred only to schools, and it said this law is applicable to schools. But the schools then were asked by the Education Department to set up a whole set of litigations, if you will, about sexual harassment. Now, sexual harassment has absolutely nothing to do with the schools. It has to do with the relationships between the students. And yet here's a whole series of laws dealing with sexual harassment where not only has the Department of Education defined sexual harassment, but then it's determined how much evidence you have to have in order to convict someone, and then what the punishment should be. And all of those things do not come out of any statutory language at all. It was something that the Education Department used, even though it didn't actually reflect something that Congress had adopted.
Now, you point out in the book, and it's called Judicial Fortitude, The Last Chance to Rein in the Administrative State by Peter Wallison, that the framers really anticipated that the legislative branch would be the most powerful of the three branches. But today, Congress is, in your mind, by far the weakest. Now, of course, we're going to see some gridlock. We're going to see some bipartisan activity in the next Congress, and perhaps it will rear itself again in distinction to what's going on in the executive branch. But explain to us why Congress was intended to be the strongest and is now the weakest branch of our government as you see it.
Unfortunately, Congress has discovered that it doesn't have to control the government. It is, as it was intended by the framers of the Constitution, Congress would pass laws and control the government. But what has happened is that Congress has realized that to make all these laws, especially those that attempt to impose controls of some kind on the public, means that they will have more difficulty getting reelected. And so over time, what they have decided to do is not to try to make all these tough decisions, but simply hand over the power that they ordinarily have to the executive branch and primarily to these agencies. There are also other factors, and that is once the party system became established, which was not really contemplated by the framers, it turns out that when the Congress and the president are of the same power, Congress gives the president a lot of authority that they might not otherwise have provided to a president of the other party. And so we have times like in the Roosevelt era and again in the Johnson era after the assassination of President Kennedy, and again just recently when the Obama administration came into office in 2008, that tremendous amounts of authority were provided to the president by Congress because the Congress and the president were of the same party. Those things remain in place and are never repealed once they have occurred. And so Congress has largely given up a lot of its authority, not only for political party purposes, but also because it's hard to legislate and they don't want to do it.
It's interesting because I read where there was some columnist who wrote that a lot of what goes on in Congress today is super punditry. They've all become pundits, but they're getting nothing done. Well, that's interesting.
Yeah.
In your book, Judicial Fortitude, you argue that the administrative state ultimately threatens our nation with a Brexit-like crisis of legitimacy. Explain that.
This is actually the most important thing in the book and the reason that I wrote the book. And that is that as more and more of the rules that people have to obey are made by agencies and unelected officials of agencies, the American people gradually will come to realize that they are having very little effect when they elect their congressmen and their senators. That in fact the rules are going to be the same. They're going to come out from the government, whether a Democrat or a Republican is elected to Congress, and that raises questions about whether we are really a democracy. And in the book, I analogize this to what happened in England with Brexit, because the whole case of Brexit, the whole reason it arose was that the British were very unhappy about regulations that were being made in Brussels over which they had no control at all and were going right into the statutory law and the regulatory law of the British Isles. And so their unhappiness there caused them in 2016 to vote to leave the EU. And the reason that happened is that they did not feel that the EU was a legitimate government. A legitimate government in our world today is a government that in some way obeys the citizens through some sort of democratic process, which we have had since the late 1700s, and Britain has had even longer. But when people encounter a situation where the government is no longer responsive to their desires, and they seem to be subject to regulations that the people they elect had nothing to do with, the government then loses legitimacy. And so unless we can get this whole system of administrative agencies and the administrative state under control so that the American people have confidence that when they elect Congress and Senate, those people are going to be controlling the kinds of regulations that come out of the government, we are at some point in the future going to have a crisis of legitimacy in the United States.
Anything that
point
people can
also-
do about it? Is there anything we can do about it?
Nothing that can be done directly, except that people ought to be talking to their neighbors and writing letters to newspapers and so forth, saying that we have to do something about the fact that most of our rules are now being made by executive agencies, administrative agencies, over which we have no control through our votes for Congress. And I suspect that what will happen when the 5 members of the Supreme Court are finally beginning to focus on a case where, say, the Chevron matter is before them, and they decide that they want to eliminate or substantially modify Chevron, there will be a huge backlash from the people who like what the agencies are doing. And that, unfortunately, is largely people on the left who aren't really particularly concerned about whether the American people are supporting something or not. They're more interested in the policies that are being done rather than the procedures through which those policies are implemented. And so there will be a huge controversy about eliminating or modifying Chevron. And if people who are listening to this radio program will think about this in terms of what they ought to be doing to prepare for a time when there is a real challenge to the agencies, that would be very helpful.
Judicial Fortitude, the last chance to rein in the administrative state. Peter Wallison, our guest. And thank you so much, Peter, for coming back and sharing this with us. Very interesting topic, and one that I'm sure people will want to think more about as we move along. But you've given us a lot to think about, and a book that really grounds it in our history and our Constitution. Thanks again for coming by on America Trends.
I appreciate your invitation. Thank you. Bye-bye.
Hey, Larry.
Yeah, what's up,
I
John?
got some exciting news for you.
Well, let's hear it.
We're part of the MHNR network.
And where can we find that?
That's MHNRnetwork.com.
I'm going there right now.
All right.